Okay, if I could have all council on mute, please, we'll go on the record in Kent Family Farm versus Bond. This is file number 2419708. And if I could just have all council put your appearances on, please.
Paul Slough on behalf of the plaintiff.
Jeff Shimovitz on behalf of Ben Vaughn.
Drew Norton on behalf of defendants Rosemary Curatello Trust and Michael Yenis.
Melissa Pranzalis on behalf of defendant Mertz.
All right, thank you. We're on the record today for two things. Number one, we have a status conference, and which was set for 1:30. We also have a motion on a hearing regarding an objection that was set for 3. I'm not sure if that was, I have that crossed out on my docket. Did that get changed?
It looks like he withdrew his motion
Okay,
or his objection.
Mr. Shimovitz, you withdrew your objection, is that correct?
Yes, sir, I did.
Okay, great. So I guess we're only on the record for one thing then. And that would be the status conference. So I guess in terms of scheduling going forward, Mr. Slough, I'll just start with you. Where are things at in light of our hearing last month, and what do you think we need to do for scheduling going forward?
We don't have any more discovery to perform, Judge. There is one outstanding piece of discovery that Mr. Shimovitz and I have talked about, and I understand that he's working with his client to produce a walkthrough video of the home in question. But other than that, we've conducted all the discovery that we intend to perform.
All right, are you anticipating any dispositive motions being filed? Do we need to set a cutoff for that?
I'm not planning on filing a dispositive motion.
Okay, Mr. Shimovitz?
Yes, sir, we have only the deposition of Kent Family Farm's principal member, Josh Kent. That would be all that we anticipate at this time.
Okay, are you anticipating any motions from your side?
No, sir.
Okay, Mr. Norton?
Yes, Judge, in addition to the Kent representative deposition, which we are interested in as well, we will likely take the deposition of one of the brokers for purposes of our third-party claim. We've been kind of sitting on the sideline watching the property owners kind of duke it out for the moment to see where that was going and if that was going to generate, I was hopeful, some sort of settlement that, we would participate in, of course, but that doesn't look likely. So sorry, that was a long-winded answer to say the Kent deposition plus one likely.
Okay, thank you. Ms. Pranzalis?
Yes, Judge. No, MERS does not anticipate any discovery. We really are simply kind of sitting on the sidelines as well with regard to the dispute. Obviously, my client holds the mortgage on the property. Depending on what type of settlement may or may not come between the parties, we may then get more involved as it relates to, potential legal description things, possible discharge, maybe a partial discharge or something of that nature, depending on what they come about with. So my client really doesn't have any stake in the game, so to speak, until they reach some type of resolution.
Okay, understood. I know that the parties did participate in mediation. I'll open it up to Mr. Slough, Mr. Shimovitz, or Mr. Norton. Is that something that you want to take another stab at, or should we just get this on? I'm assuming this would be a bench trial. Should we just get it set for a final hearing? Mr. Slough, from your side first.
I think that if there's any likelihood of a resolution, then Mr. Shimovitz and Mr. Norton and I will be able to work it out between ourselves. I don't think that it would be particularly constructive to set aside another day and have the mediator come back. Some cases that is helpful to do multiple rounds, and I don't see that happening in this case.
All right, do you have a jury demand for any of your claims?
I was just double checking if we demanded a jury. I don't think so because I think they're mostly equitable claims. Oh, we did demand a jury. And it would be on the trespass claim, I guess, since that would be a money damage issue.
Okay, is that how you still want to proceed?
I think it would be premature to waive the jury trial at this point, just because it's difficult to say exactly how things will play out on the other counts, such as quiet title and the Reformation claim. In other words, if the court were to find that my client is not entitled to the property, then we wouldn't have a claim for trespass. If the court finds that we are entitled to the property, then we would have a claim for trespass. And I mean, maybe there wouldn't be a genuine issue of fact at that point, but I guess there would still be a question of damages. I'll talk to my client and maybe we have another status conference and we can resolve that issue as to the jury trial, unless the defendants have a thought about that.
Well, and I'll hear from Mr. Shimovitz and Mr. Norton, but I mean, maybe we just bifurcate it and set the equitable claims for a bench trial, and then whatever's left, we could address later. Mr. Shimovitz or Mr. Norton, what are your thoughts?
Well, I concur with Mr. Slau's reading, and frankly, Judge, what you suggested makes reasonable sense to me. Bifurcate and
Okay.
do the equity first.
Okay.
From our perspective, Judge, first of all, we did not demand a jury trial. Yeah, I would favor a bench trial on everything, quite frankly. I do not see the benefit of returning to mediation. We never even got on a screen the first time. Those are these other two, after an hour and a half, we just said, the clock's just ticking here for us, and call us if you need us, and that never happened. So I don't want to spend any more money on that, quite frankly.
Okay.
I would
Right.
agree on that point, Judge.
Okay. All right. Then why don't how many days do we need to set aside for the if we bifurcate it and for the bench trial part? Mr. Slough, what do you think?
I mean, not more than 2 days. I would think maybe even a day, but just to be safe, 2 days.
Okay, Mr. Shimovitz or Mr.
I'd
Norton,
go
would
with
you?
2 days just to be safe.
Yeah, agreed. I hesitate to say 1 day for anything in this day and age.
Yeah, and my client's fairly high profile with his operation in Otsego County, and Mr. Vaughn's in Otsego County. And it could be difficult to get a jury, so I would say 2 days to be safe.
Well, again, I'm just talking about the equitable
The bench.
claims.
Oh, I
The
see.
bench.
I'm sorry.
Yeah. Okay. And if we set it at least 90 days out, is that enough time for everybody to be ready?
I think so, Judge, from Vaughn's point of view.
Yes, Judge.
Okay. So what I'll do then, I'll set this for a 2-day bench trial. It'll be at least 90 days out. I'm not sure where my calendar's at, but it'll be no sooner than 90 days, but as close to that 90-day mark as I can get. I will set it for a final status conference about 30 days prior to that date. And at that time, we can address any issues relating to witness exhibit lists and trial briefs and that kind of thing. We can address at that final status conference. And then Mr. Slough, between now and then, I mean, I guess confer with your client if we need to, if the trespass claim is something that we can address before the bench, then we will. And if not, then we can preserve that for later if necessary. Does anybody have any objection to that schedule?
No.
No objection.
You have no objection.
No objections.
Okay, so I will send out a status conference order that reflects what we've discussed here today. Along with that order, you'll also get notice of the date and time for that final status conference, as well as the bench trial dates. Obviously, if for any reason the parties are able to resolve this, just let my office know. We can take those dates down. But otherwise, our next hearing will be that status conference where we can address any and all issues that we need to prior to the bench trial. Mr. Slough, anything further I can address from your side today?
No, not at this time. Thank you.
Mr. Shimovitz?
No, sir.
Mr. Norton?
I'm curious, Judge, given what you probably encounter quite a bit on a bench trial part of it, would it be in person?
Yes, definitely. I
Okay.
should have mentioned that. That's a good point. Generally, any evidentiary hearings, whether it's bench or jury, I would have in person. To the extent that either of you or anybody has witnesses that are, a long distance away, we can get stipulations if we need to, or, to have particular witness testimony by Zoom. But generally, absent some type of extenuating circumstances, it would be part of my scheduling order that everything be in person for that hearing.
Thank you.
Okay. All right. Thank you. That's all I have. All parties are free to disconnect on this file.
Thank you.
Thank you.
Have a good day.
Ms. Slocum, I accidentally brought you in. We have one hearing before yours, so I'm going to put you back in the waiting room for just a minute.
Problem.
Okay, so we'll go on the record in Silver versus Silver. This is file number 2520217. If I could have counsel put your appearances on, please.
Lauren Madison for Ms. Silver.
Good afternoon, Judge Elliot Blumberg on behalf of Mr. Silver, who's appearing by Zoom from my office.
Okay, and the record should reflect Ms. Silver is also present by Zoom. I have this set for a status conference here today. I believe this is the party's first hearing before the court. Ms. Madison, can you tell me kind of where things are at from a plaintiff's standpoint and what you would like to request for scheduling going forward?
Thank you, Your Honor. At this point, the parties need to exchange some discovery. Mr. Blumberg was just brought on board, I believe, last week or the week before that. Given that we have some exchange of financials that we need to accomplish. Additionally, we are asking for an order for mediation in about 60 days.
Okay, Mr. Blumberg?
I think that's an accurate statement. We hadn't really talked about how much time for discovery. I would ask the court for 90 days. But we've talked about exchanging discovery and then going to mediation to hopefully resolve the issues in this case.
Okay. All right. I mean, I think 90 days is a reasonable period of time. So we'll set aside 90 days for discovery. I will order that the parties participate in mediation within that 90 days. So, whether that's 60 days, whenever the attorneys feel that they're ready based on the state of discovery. And then I will set this for a status conference at about 90 days. If the parties have been able to resolve, then we can use that date to take proofs and enter the judgment. And if not, we can discuss further scheduling. Ms. Madison, any other dates I can address for you today?
Not at this time, Your Honor.
Mr. Blumberg?
No, Judge, thank you.
Okay, so I will send out a status conference order reflecting what we've discussed here today, along with a notice of the date and time for that next status conference in 90 days. And all parties on this file are free to disconnect. Thank you.
Thank you.
Thank you, Judge.
That next one, both, I guess both of the next ones.
The All-American got taken down, correct?
Oh, it did?
I think so. Let me pull it up really quick.
Yes. Hart one.
Oh, no, it didn't. Okay, no, I'm sorry. I lied to you. There's the All-American and the Hart.
Thank you.
Mhm.
Okay, we have both counsel connected, so we'll go on the record in Hart versus Hart. This is file number 2520242. If I could have both counsel put your appearances on.
Good afternoon, Your Honor. Jennifer Dutzman-Coy on behalf of Mary Beth Hart, who is the plaintiff.
Attorney Samara Slocum for Ian Hart, who's the defendant.
Okay. Looks like this is our first status conference. Ms. Dutzman-Coy, can you tell me where things stand with this file and what you would like to see for scheduling going forward?
Sure, Judge. This is a relatively new divorce case. The parties are in the process of providing their disclosure forms to each other. I've already received the defendants and we're preparing the plaintiffs. And so we should have that to them this week. Mr. Slocum and I had the chance to talk a little bit. What we would like to do is to set this matter for mediation. We've agreed on using community mediation services. And then I think we'll continue to do private negotiating. The parties have been able to do a little bit of personal property separation so far. So things are, I think, progressing pretty well without court involvement at this point. So, and hopefully that will continue, but we'd like to go to the mediation and kind of see where we are after that.
Did you have a deadline in mind for that mediation?
I'm hoping that we can get in by the end of the year because the parties had been before the court a few weeks ago and they were concerned about their household expenses continuing and they were going to revisit that before the end of the year anyway. So hopefully by the end of the year, but I think 30 to 60 days would be fine.
Okay, thank you. Ms. Slocum?
I would agree with that, and I don't have anything further to add.
All right, so for purposes of the status conference order today, I'll just indicate that the parties to participate in mediation within the next 60 days, and then I'll set this for another hearing at 60 days. If there's been a resolution, we can use that date to take proofs and enter the judgment. If not, then we can discuss further dates. Ms. Dutzman-Coy, anything else that I can address for your side?
No, thank you.
Ms. Slocum, anything further for your side?
No, thank you, Your Honor.
Okay, thank you. That's all for today, and you're both free to disconnect.
Okay, thank you, Your Honor.
Okay. Mr. Newman, you're appearing on behalf of All-American, is that correct?
That is correct, Judge. I also have a representative of the company who appears as Scott Bright on the Zoom session.
Okay, thank you. And Mr. Tuari, you're associated with Travel Lodge of Gaylord, is that correct?
Yes, Judge. Okay.
All right, we're on the record then in All-American versus Travel Lodge. This is file number 2520078. This was set, the last time I have in my notes from October indicated that the parties were likely to reach a resolution. So Mr. Newman, can you tell me where things are at from your client's standpoint?
Judge, we believed we had a resolution. My client made arrangements to effectuate that resolution, and we weren't able to achieve it with the assistance of the defendant. I don't want to get into the details of it under MRE 408. It wouldn't be appropriate to publish to the court what the terms of that were, but it did not happen. The court as a backup had set this matter for a status conference today because we weren't able to resolve it with what I believe was a resolution negotiated between the parties. I filed my motion for entry of default judgment. The defendant was defaulted back in back in August of this year. We've been holding off moving forward pending what we thought was a negotiated resolution.
All right. Mr. Tawari, is Travelodge, is that a corporation? Is that an LLC? What's the nature of that business entity?
It's an LLC.
Okay. So, as you may be aware, are you a licensed attorney?
I am not, no, but we would like to resolve the issue and set a date for the transfer. I think we had set it up before, and Scott and I miscommunicated on some of the fine details at the last minute to get it resolved. I do want to see if we can just set the date on this call, Mark, if that's possible, to exchange the pool tables that are in question. But yeah, with the holiday travel, I'm also not present at the property, and it's ran through a third party. And that side of the hotel has been closed down. So in fact, we might actually need to bring a locksmith to open up the area where the pool tables are. If it was in a common area, I could let you go in right now, but I don't even know how to get into that room, is what my manager tells me.
Well, Mr. Newman, do you want me to put you and Mr. Tawari into a breakout room for a minute so that you can talk off the record?
If the court would indulge us, I would appreciate that. If you could also put my client, Mr. Bright, in that room with us, because he'll make that determination as to date and time.
Yeah, certainly. So let me just do that. It'll take a second here.
Thank you.
Okay, that room should be open for all three of you. And, feel free to take as much time as you need. I don't have a super packed docket this afternoon, so I can work you back in once you're done. Okay, 1 second here. Okay, we're back on the record. Mr. Newman, can you tell me where things are at this point?
Yes, Judge, appreciate the court's indulgence. We had a meeting in the breakout room. We now have a date and time certain of December 11th between 11 and 1 for an exchange of the property in question. Defendant's representative, Mr. Tuari, is going to make arrangements with the people on site to make access for my client to be there. He's going to bring a crew and the necessary vehicles to remove the property. I did advise him I'd be asking the court for a new hearing date for this motion, so that if it doesn't happen on the 11th, the exchange, then we're going to be heard on our motion, ask for an order and money judgment at that time. I did advise, and I just want to state on the record that this is the last adjournment of this resolution of this case. So, and obviously, if we do get the equipment back that we're supposed to give back, we'll enter an appropriate dismissal order with the court.
Okay, thank you. Mr. Tuari, did you have any questions or anything for the record based on that?
Nope, thank you.
Okay, all right. So I will issue a status conference order that just reflects kind of Mr. Newman, what you've reiterated there. I will not set this for further hearing. So Mr. Newman, to the extent that you need further court intervention, that you would need to get a date and set that, okay?
Very good, Judge. If it doesn't happen on the 11th, then I'll contact your office for an appropriate hearing date on my motion.
Okay, thank you. That's all for today. You're all free to disconnect.
Appreciate you all.
Thank you, Judge.
Thank you.